This is position 8 on our revocation calendar, State versus Thomas Smith, 25 SC 006-526. Mr. Smith, you're charged with 1 count of aggravated stalking. You and I have had a number of conversations about options, one of which was accountability courts. This was when Ms. Kim, I think, was one of the lawyers in the mix. But we're going to, I think, go forward with a plea now. Is that your understanding?
Yes, sir.
Okay. Counsel, if you could state your name for the court reporter.
Yes, Your Honor. Carlos Mucha, M-U-C-H-A. And I work with Ms. Kim. She's still his counsel as well. My understanding is it's a first offender plea, and then he'll be in accountability court.
Okay. Well, let's work our way through it. See if that's how it plays out. Ms. Nix is going to put you under oath, Mr. Smith, and ask you questions about your case and your rights. Please listen to her carefully and answer carefully. If at any time you've got a question, I need you to let Mr. Mucha or me know that. Will you do that?
Yes, sir.
Okay. Ms. Nix.
Judge, Mr. Smith, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Please state your true, correct, and legal name.
Thomas Clifford Smith.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there a medication that you normally take that you have not taken or been given today?
No. Well, I didn't get my insulin this morning, but that's it.
Insulin is the only medication you're taking at the jail.
That was what I didn't get this morning.
Got it. There were some medicines you took this morning?
Yes.
And tell me, for what do you take those medicines? What do they help with?
I took 10 milligrams of.
You don't need to name the medicine because those are hard to spell.
Okay.
I need to know for what I take it because I have headaches. I take it because I have a broken wrist.
One is an antidepressant and one is a mood stabilizer.
Okay. And you got both your mood stabilizer and your antidepressant this morning?
Yes, sir.
When you take those, do they make you woozy or drowsy or feel out of sorts?
No.
Thank you.
How old are you, Mr. Smith?
41.
How far have you gone in school?
I have a 4-year degree.
Is English your native or dominant language?
Yes.
Do you understand that you've been charged with the following offense, aggravated stalking?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to this charge?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charge against you at a jury trial?
Yes.
Have you had the opportunity to review your rights with your attorney?
Yes.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes.
Do you need more time to discuss the case with your lawyer, Mr. Mucha?
No.
Are you satisfied with his services?
Yes.
Mr. Mucha, do you waive a formal reading of the indictment for purposes of the plea?
I do, yes.
And do you waive any and all defects in the indictment for purposes of the plea?
I do, yes.
Mr. Smith, do you remember having been arrested on this charge?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, I'm aware of them.
You understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court. State recommends a 5-year sentence with the conditions, probated sentence with the conditions that you complete drug court and have no contact with Marlena Smith.
Yes. Does that mean this is?
Well, they share a child, so there's for co-parenting to
Between for the period of 5 years or for the period of the no contact order? That's the confusion that I have.
For the period of
So it would, well, you go ahead. What are you recommending?
I'm recommending for the period he's on probation, that you have no contact with Marlene Smith.
Right. That typically a condition of probation is coextensive. It lasts as long as your probation. If your probation ends early, that condition ends early. But it would be at most 5 years of no contact with Ms. Smith. Now, we may need to define what no contact means. If you have a child together and you are going to engage in co-parenting and you're authorized to engage in co-parenting, Either you would need to have contact with Ms. Smith, or we'd need to designate who the third party is who coordinates that, who is the go-between. So you would call Stan Smith, and Stan Smith would call Marlene Smith saying, hey, it's time for Thomas to pick up the boy or the girl.
Girl.
A girl. Going to pick up the daughter at this place at this time. But we'll work through that.
I guess as long as the probation officer, has the authority that they can designate someone.
No, we would be working through that now. We wouldn't leave it open. So we'll talk about it.
Okay.
Keep going.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on this charge?
Yes.
I think we're still at final plea posture. Is that right, Judge?
I believe so.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
No.
You understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
You understand that while you're on probation, you must follow all the special conditions of your probation?
Yes.
You understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes.
Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes.
Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pled guilty or nolo contendere to a felony in the state of Georgia?
No.
Have you ever pled guilty to a felony in any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked?
Yes.
This means that you could be adjudicated guilty and resentenced up to the maximum sentence for each charge in this indictment?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charge of aggravated stalking in indictment number 25 SC 006526?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal as
Yes.
outlined in OCGA 5-6-35 within 30 days of today?
Yes.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition, and you only have 4 years from today to do so.
Yes.
Judge, had this case gone to trial, the state would expect the evidence to show that between the days of September 18th and September 24th, 2025, the defendant did contact Marlena Smith, that's Marlena Smith, common spelling, without the consent of Ms. Smith for the purpose of harassing and intimidating Ms. Smith in violation of a temporary protective order which prohibited such behavior by Thomas Smith. And this occurred in Fulton County. The defendant does not have any criminal history and is eligible for first offender.
All right. And have you spoken recently with Ms. Smith or someone in your office?
We have, I spoke with her a few months ago, and she is on board with the defendant going to accountability court. She does want no contact with him and wants him to have no firearms. And I did tell her that that he was eligible for accountability court and that that's what we would offer. That probation has a standard condition of no firearms, and that I would definitely make no contact a condition of his probation.
Did she relay anything about who has custody of the daughter?
The son?
She has custody of the daughter.
Daughter, I'm sorry.
And I do not know if I asked her, I do not have notes about whether they have a visitation order.
Okay. All right. Ms. Smith, ma'am, do you have anything that differs in terms of criminal history? It's sounding like Mr. Smith is eligible for first offender.
He is, Your Honor. There's just 2 prior arrests, not including the one before you, one misdemeanor conviction, 2010 Cherokee County Sheriff's Office DUI. Nothing further, Your Honor.
Okay. Thank you so much for your help today. You are good to go.
Sorry, Judge, one more thing.
Thank
The
you.
daughter was included on the TPO that led to this case.
The daughter was, so it was no contact with mother or daughter.
Correct.
Okay. All right. Mr. Mucha.
It didn't say no contact. 200 yards.
Oh, yeah, I guess the order said no contact, but not within 200 yards. But he's relaying to me what the TPO says.
That's what I have in my notes. I'm pulling up the TPO to confirm.
Right. And there has not been a visitation order issued for custody of the child. So
She has a 1-year temporary custody based on the TPO. But what I was curious about was can I just speak openly?
Please.
Basically, I was,
How old's your daughter?
she's 6 years old.
Okay.
And, you know, I'm not the same person that I was 9 months ago. I've had a lot of time to think about what's important to me. And first I'd like to, I want to take accountability for my actions. I am fully aware of the negative consequences that I have had on my wife and daughter. And, that weighs on me significantly. I have remorse for those, for my actions. And I understand, what I did. But I don't understand what's going to happen as far as me getting to see my daughter because she's innocent in all of this.
So the answer is let events unfold a little bit longer. What I'm going to do, assuming we go forward with the plea, is set some basic conditions to your sentence, and I'm happy to modify them if drug court's going well. You have a 50-50 chance to be in drug court with me. There are 2 drug court judges. It may be you're with me, you could be with Judge Krause. But if you're with Judge Krause, she can let me know how things are going. It is not at all uncommon to have drug court participants after they get a few months of proven sobriety under their belt and strong performance in drug court to say, hey, could I address a condition of my sentence? I want to be able to be around my spouse or my child or whatnot. And that's one of those, let's see how you're doing. And that would involve the state reaching out to your wife and saying, hey, things are a little different. Mr. Smith would like to have access to the kid or your daughter. You also have that 1-year clock that is almost over. If it was a year back then, you can see we're in June. And so it will be up soon. And so those are all important subjects to discuss. Today isn't the day we resolve them. In fact, today would be, if we go forward with the plea, would be, all right, next up is getting you into drug court and getting a couple months of good, sober performance in drug court. And then it's natural to say, well, you know what, I'm going to start working again. How do I reintegrate into the life I had? And Your wife gets to exercise her decision about whether your life going forward involves her. Your daughter, as long as it's safe and it's in the best interest of the child, and it typically is because she's 6, she's not 6 months. So you were present in her life for years.
Right.
What would be in her best interest would be to be able to spend time with you, assuming you are functioning and not doing something scary. So you earn that, and you may well earn it quickly through a few months in drug court. But we'll assess that a little bit later. I think it would be premature to say, great, at the 3-month mark, you get 6 hours a weekend with your daughter and then this and that. We're also not the parenting experts in drug court or right here. There'd be someone who would assess what's in the best interest of your daughter. And we would marry that up with how are you doing in drug court? That's the part you control. And if you're doing well there, then you present the best face to that situation. Does that make sense?
Yeah, so basically what I was trying to clarify was that sort of like when the no contact order expires, this stipulation kind of takes over and can be revisited through the ongoing my progress through the drug court and stuff.
Correct.
All right.
Exactly right.
And finally, I just want to say that, I apologize to everyone who was involved in this case, especially my wife and daughter.
Okay.
And
Well,
I appreciate the chance to redeem myself.
good. Let's use it wisely.
Thank you.
Anything you want to add? That was pretty well spoken, Mr. Mucha. Anything you want to add?
Only, Your Honor, coming out of into the drug court program, he's been in custody a while. He doesn't have any funds. I would just ask if you could waive probation fees for at least the first few months. And I'd like to seal the arrest record, if not right away, at some point. So when he's seeking employment, the arrest doesn't show on there.
Sure. So a couple things on that front. One, there are no probation supervision fees while he's in drug court. His probation will be on an administrative status. He won't be reporting to probation. There are drug court fees, but those are pay as you are able and are waivable until people are working.
Do they offer the FFIB? I know that's something that he'll need to go into.
The FVIP, yeah. On the TPO, it said I have to do these family violence intervention program courses. And I believe that you go through kind of like, it's like going to a DUI school or something where you pay an agency to do classes, I think.
I'm sorry. I'm stepping in for Ms. Kim. That's through the TPO. That's not a part of the sentence. I thought that the FFIB was part of the sentence. I apologize.
I didn't hear Ms. Nix recommend that. So there would be counseling he can get through drug court as well.
Okay.
All right?
All right. Thank you, Your Honor.
You're welcome. Did I say anything wrong about probation, or in fact the fees are waived as long as he's in drug court? Okay, I didn't make that up. All right, Mr. Smith, I find there's a factual basis for your plea in that your plea is knowing, meaning you've understood what we talked about, and voluntary, no one forced you to plead. I will accept it. I appreciate you are seeming very self-aware right now. That is healthy. I hope you maintain that. Mr. Mucha, can someone in my office sign the indictment on your behalf and your clients?
Yes, Your Honor.
Ms. Nix?
Yes, sir.
All right. Mr. Smith, you qualify as a first offender. I will sentence you as a first offender. It is primarily a benefit. It means that this is not a felony conviction. You will be under sentence. You may not have a firearm while you are under this sentence, but at the end of your sentence, you remain not a convicted felon. That helps with work, if you want to go on to graduate school, et cetera, et cetera. It carries a risk. If you derail 6 months in and you leave drug court and you relapse or something happens, not only will you have new charges, but the state can petition the court to revoke your first offender and resentence you up to the maximum. So you'd have a bunch of years you could be looking at. Not if you jaywalk, but if it involves something where you were threatening towards your wife or something like that, that would be a signal that first offender didn't make sense, that you don't have things under control, and there could be some pretty serious consequences. Do you feel like you understand the risks and benefits of first offender?
Yes, sir. I see the risk reward.
And is it your request to be sentenced as a first offender?
Yes.
Do you need housing? Because we have temporary stable housing through drug court.
Yes, I do. I believe last time, Miss Kim said that I was able to get,
90 days.
well, she said she was able to get double, like 180 days, like double that.
Well, I wouldn't worry about the numbers yet, but you or someone has told drug court that you need housing?
Yeah.
Okay, they'll take care of that initially. I will sentence you to 5 years to serve 9 months with the balance on probation. Special condition of probation number 1 is that you enter into and successfully complete drug court. It means if you're terminated from drug court, I could revoke all your probation, not a little, but all. And special condition number 2 is that until further order, you will have no contact, direct or indirect, with Ms. Smith. If we need to develop a way for you to spend time with your daughter, we can come up with that third-party conduit. Or it may be after a few months of drug court, your wife says, you know what, I'm okay having communication solely about visitation. But that'll be her call. What won't be her call is your ability to spend time with your daughter if in fact you have legal custody of her as well. And then we would need to develop that third-party transfer, okay? Ms. Nix, anything else on behalf of the state?
No, sir.
Mr. Mucha, on behalf of your client?
No, Your Honor, we think we covered everything.
Okay. Ms. Simpson, does Mr. Smith need to at least report, or he just needs to go to drug court and probation will lift off from there? Okay. There you go. Any questions?
No, Your Honor.
Okay. Good luck, Mr. Smith. I may see you in drug court.
All right, thank you.
Thank you.